All right. Well, welcome everyone. Thank you for joining me. My name is Lior Samfiru. You know who I am, hopefully. I'm the employment lawyer. And as an employment lawyer, I talk about employment law. And that is what we do here on this session every week. I log on here, I talk about employment law, and I try to inform and educate you on your employment rights. I'm one of the founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in this country, operating in Ontario, in BC, and in Alberta. And I'm here to help you. I'm here to provide answers to your workplace questions. I'm live. This is a live Q&A session. So if you have questions about your workplace rights, or if you're facing a workplace problem, this is the opportunity you have, the time you have to ask a question, to get answers, to get solutions, to feel better about what you're going to do. Maybe you're not looking forward to going in tomorrow and you want to know what to do, what to say. Well, ask the question. Maybe you lost your job. Maybe it's a vaccine mandate question. Maybe you're put on a temporary layoff. Maybe you're suspended or given a negative performance review. What do you do? What do you say? Can you deal with it? Ask your questions. I promise I'll answer it right now, and you can walk away having that information. Of course, if you want to connect with me off air, if you want to have some private discussions by phone or email about your specific matter, let me tell you how you do that. All you do is you go to employmentlawyer.ca. Again, employmentlawyer.ca, the way to connect with me. And by doing that, you can have a private chat with me and my team so we can actually get to work to help you. So, it's nice to ask a question here on this session. I encourage you to, but to take it to that next level where we can actually do something for you, easy, just go to employmentlawyer.ca. Again, I'm Lior Samfiru. I'm the employment lawyer. I'm live answering your questions. I'm going to start answering questions right now, but you have some time, but don't wait till the last minute. There's always people asking questions right at the very end, and I can't get to them sometimes. So please, now that there's some time, ask your question. Don't be bashful. By asking a question, not only can I help you, you will be helping others. They may have the exact same issue or same question as you. So please take advantage of that and ask your question live. So first question today from Facebook comes from James. Can you negotiate the contingency fee of 33%? Well, we're not the market in Istanbul, right? So our fees are our fees. We are fair, and sometimes our fees are less than that, but our fees are our fees. We don't negotiate our fees. Okay, again, we're not. This is not the market where we say this, you'll say we'll give you that. No. So our fees are our fees. Okay, next question from Maxi on YouTube. Okay, I work for X Limited for 3 years. 3 years ago, staff moved to another company. Our department did not move for systems reasons. We are to receive an offer to join the other company next week. Our jobs are being advertised in Western Canada and now on LinkedIn, and the head office is moving. I'm concerned the company is tricking us to join and then put us on working notice. Have a lot of tenure over 26 years. So the key here is this: if you're going to move to another company, the company sold, etc., you want to make sure you don't sign anything that gives away your seniority. So if you don't sign anything, you just continue working with a new company. If they want to let you go, they can. You can't stop that, but they'll have to account for your 26 years seniority, and they'll have to give you either 2 years notice or pay you 2 years severance. You can't stop someone from letting you go. But what you don't want to do is to sign something saying that the new company does not take on your seniority. In that situation, you could be in a terrible state where you start working with the company and then they let you go and they don't pay you severance or very little because you gave up your seniority. If you are asked to sign anything, okay, Maxi, as part of this move, anything, give me a call, send me a copy, let me look at it, let me tell you what it means. If you're not signing anything, you're fine, you're good. But if you're asked to sign anything, I want to see it. All right. And again, to connect with me or my team, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. All right. Next question from AJ on YouTube. My employer rejected my request for a vaccination exemption. I argued that I am a permanent work from home employee years before the pandemic happened and already got the virus and therefore naturally immune. I was given 8 weeks to comply or be suspended. I want to treat this as a constructive dismissal and fight for my severance. Well, that's exactly what you can do. If in fact you are suspended, okay, or let go, you're owed severance, absolutely. But we have to wait for that to happen. As soon as that happens, you're owed severance. Now, this is especially true since you're working remotely anyway. You say even before the pandemic. Well, obviously, there can be no rationale to make you be or to want you to be vaccinated when you're not even in the workplace. You're not protecting employees because you're not there with them anyway. So yeah, you're absolutely going to be owed severance. And I don't know how long you've worked there, AJ, but that could be as much as 2 years pay, depending on how many years you've worked there. So as soon as you're suspended, as soon as that happens, you call or you email. Just go to employmentlawyer.ca. Again, employmentlawyer.ca, and we'll get to work to help you. It's not hard. It's not complicated. We're representing hundreds of people across Canada in exactly this situation. We're resolving cases every single day. So let's have that chat. You as well at home, if you're suspended, if you're put on a leave of absence, if you're let go because of your vaccination status, you likely have very significant entitlements. So just give us a call, send an email through employmentlawyer.ca, and let's have that chat. For those joining me right now, welcome. My name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP, and I'm live answering your legal questions, your employment law and workplace questions. I'm going to continue answering right now. Ask your question as well. On YouTube from Simon, are federally regulated employers required to not suspend medical benefits during the first several months of putting unvaccinated workers on a leave of absence? How does this impact their severance? Well, I think you're getting ahead of yourself, and what I mean by that is the question is, are employers allowed to just put employees off on a leave of absence? And the answer is no. Even in the federal workplace, the only mandates that apply are for those in the travel industry, airlines, trains, etc. Otherwise, there's no federal mandate. So even if you work for a federally regulated employer, they don't have a right to suspend you. They don't have a right to put you off work. So that's the real question. If they, in fact, they suspend you, they put you on a leave, you can treat that as a termination. We call that a constructive dismissal and require them to pay you severance. So it's not a question of benefits. It's a question is, do they even have a right to suspend you? And the answer is no, they don't. So if you're in a non-union workplace, if you've been put off on a leave of absence, you got to give me a call, okay? You got to give my team a call, connect with us. Again, employmentlawyer.ca. Again, employmentlawyer.ca. Thanks for that, Simon. You have a follow-up question, please ask it. Keith on YouTube. I have an arbitration status conference for wrongful termination. Can I settle my case at that particular time? Well, Keith, if you're arbitration, it probably means you're a unionized employee. So if you're a unionized employee, the only one that can answer your questions and give you advice to help you is your union. I can't do it. No lawyer can. And everything that we talk about on this session only applies to non-union employees. It does not apply to unionized employees. So Keith, you have to talk to your union. That's the only thing that you can do. All right. Next question on YouTube from Cuz0176. I work 2 full-time jobs hired by the companies I work for. Now, in the last 3 years, I've been diagnosed with a long-term disability. I was wondering if I can go on short-term disability for each place that I work for. Do I have to quit one of my jobs? Well, no. I mean, listen, you first of all, in terms of being off work, all you need is a doctor's note, okay? If you have a doctor's note, you can be off work from both jobs or one of the jobs. If your doctor says you need to be off both jobs, then give each workplace a note, and you can be off to get better and you're not losing your job. If you're asking about qualifying for short-term disability benefits, if you have a plan in each workplace, then you should apply for those benefits under the disability plan, and you should qualify. If you only have a plan under from one job, then apply for that one. But you can be off work for one or both. Your doctor may say, yeah, you're okay to work in this job, but not in that job. As long as that's what your doctor says and you have a doctor's note, that's all you need. So no, you don't quit no matter what. Why would you ever quit? Either you're able to work or you're not able to work. And if you're not able to work, you can be off work as long as your doctor says you need to be off. Okay, so hopefully that makes sense, Cuz. If not, please ask another question. Let's see. Next question from Archie on YouTube. I don't currently have an employment contract at my job. I was hired verbally and have been there for 13 years. Should I request to be given a written contract? No, 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 absolutely not. For an employee, the best thing ever is not having a contract. The handshake deal is the best deal ever for an employee. For an employer, the opposite. An employer should want and insist on a written contract, but for an employee, absolutely not. The fact you're under an oral contract means you have the full protection of the law. All the employment laws that we have apply to you. What a written contract does is it takes away some of those rights, because you have a lot of rights, but you also have the right to give them up. And an employment agreement often gives up those rights. So no, this is a very important question. I've spoken about this a lot. For an employee, you are much, much better off having a handshake deal or write something on the back of a napkin at the coffee shop. That is much better than having a 10-page agreement. So absolutely don't ask for it. I'll say something else. If you were presented with a written agreement, be very concerned about it. Be very worried. That's bad news, okay? So if that ever happens, let me see it. But no, 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 definitely do not ask for it, okay? Great question. Guys, continue asking questions. Then for those joining us, my name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. I'm the employment lawyer. And what am I doing here? Well, as you can see, I'm answering your employment law questions. I'm telling you what you need to know about your workplace rights. That's exactly why I'm here. That's exactly why you're here, to get those answers. So don't just listen. Listening is great. I appreciate it. But ask your question. The best way I can help you, if you ask your question and you give me that opportunity to answer it. I'll continue answering some questions right now. Question from Tanya on Facebook. How can I prove a wrongful dismissal? My employer let me go under false allegations. Well, your employer is the one that has to prove the allegations. You don't have to disprove them. They have to prove them, okay? And unless they can prove that you did something awful, something terrible, then it's a wrongful dismissal unless they pay you your full severance. Remember, if your employer pays you your full severance, they're allowed to let you go pretty much for any reason. But some employers say, well, we're not going to pay you severance because you did these things. Well, unless they can prove that what you did was terrible and awful, they have to pay you full severance or it's a wrongful dismissal. So don't think about how do you prove it. They have to prove it. Okay, it's their onus, their burden. And if they can't prove it, they're done. Okay, they have to pay you and then some. So here's the best advice I'm going to be able to give you, Tanya. Call me. Okay, let's talk about it. I want to know more about your job, your compensation. I want to know what the company said happened. I want to know all the history there, and I can tell you exactly what you're owed and how to best deal with that. So I look forward to your call, Tanya. You can reach me and my team through employmentlawyer.ca. Again, employmentlawyer.ca. Now, I mentioned severance just a moment ago. If you want to find out right now how much severance you are owed, here's what you do. The easiest way to do it: grab your smartphone, your tablet, your desktop, laptop, whatever you want, and go to pocketemploymentlawyer.ca. See that address below me, pocketemploymentlawyer.ca. One of the tools that we have there is our severance calculator tool. You clicked on it, you use it, it's free. It's anonymous. There's no names to put in, no credit cards to put in, nothing, okay? You don't have to put in the company's name, and you can find out in seconds how much severance you are owed. And here's the thing, you are likely owed a lot more than what you believe, what you realize, and if you've been let go, you're owed probably a lot more than what you've been offered. 90% of people, when they're let go, the severance that they're offered is a lot less than what they're owed. So you need to have this information. If you've been let go, use our calculator. Go to pocketemploymentlawyer.ca. If you're worried about losing your job, we've already spoken today with a couple of people that are worried about losing their job. Again, pocketemploymentlawyer.ca. Maybe you just are curious and you want to have this information available. Again, pocketemploymentlawyer.ca, the very first place you go to if you lose your job, and tell others about it. We've had over 2 million people use it already. Tell people about it. If you know your friend, your relative, your neighbor is losing their job, tell them. Just you have to go to pocketemploymentlawyer.ca. You'd be surprised how much you are legally owed. All right. So let's see. Continuing answering some questions. Again, ask your questions. I'm live now answering your questions. From Simon on YouTube. Sorry. to your knowledge, are changes to the Canada Labor Code related to including mandatory COVID vax going ahead? No, I don't believe that there's any changes coming about making vaccines mandatory. The government of Canada announced back in December that they're going to do it. They're not going to do it. We're now moving towards less mandates, not more mandates. So I think that the Prime Minister is likely hoping that everyone forgot about that promise. I don't see that happening unless we get a massive wave of the virus. So no, I don't expect any changes. So let's see. Next question is from Darlene on Facebook. If a company closes but gives 2 months notice, do they still have to pay severance pay to the employee? Well, if that employee is owed more than 2 months, then they have to make up the difference. So you may be owed 8 months severance. If they give you 2 months notice, that 2 months counts towards your 8 months, but they still have to make up that difference, which means they still have to pay you, in that example, another 6 months of severance. Now, if all you're owed is 8 weeks, then they give you 8 weeks notice, then no, you're not owed anything. But most people, unless it's a very entry-level position that you only worked in for a few months, you're probably going to be owed more than 8 weeks. So, Darlene, to know how much you're owed, again, go to pocketemploymentlawyer.ca and use our severance calculator. Again, pocketemploymentlawyer.ca. Use our severance calculator, and it's going to tell you how many months severance you're owed. So use that information. The 2 months notice that you get counts towards it. But you are very likely going to be owed much more at the end. If you're not getting more, call me. But don't wait till the end of the 2 months. We don't want the company to shut down and disappear. Let's deal with it now. So if you know that in 8 weeks you're losing your job, let's talk about it right now. But definitely go to pocketemploymentlawyer.ca to make sure that you know how much you're owed. All right, next question right now from Archie on YouTube. I'm worried about changes to my employment. If I don't have a contract, how do I prove my work history if my employer claims I have worked for less time than I have? Well, keep in mind, your employer has records and you know they've deducted taxes from your pay. So we know how long they've been deducting taxes. There's T4s. They have all those payroll records which they have to keep. So that's not going to happen. Okay. We know exactly when you started because there's going to be payroll records going back to that. They're going to submit money to the government. So it's all on board. Don't ever worry about that. I've never in 20 years had a dispute where the employer said the person started in 2007 and the person said, no, I started in 2002. I've never seen that. Never. It can't happen. Okay. Because it's all documented. So I wouldn't worry about that at all. All right, next question from Sandra on Facebook. Can you be let go if you are on a maternity leave? Well, generally, no. The answer is you cannot be let go. You have a job. That's a maternity leave is a job protected leave. Now, the only time you could be let go is if something major happens, like they shut down the whole department and they're letting everyone go in the department and you're one of those people in the department. But even that, they can only make that determination when you're ready to come back to work. And that's very, very rare. In most cases, if you're let go while you're on a maternity leave, not only can that be a wrongful dismissal, it can be a breach of the Human Rights Code. It can be also a breach of the employment standards. So it's illegal in most cases. If you are let go while on maternity leave, even more than ever, you have to connect with me and my team, okay? Because there's significant entitlements that you may have. So again, for you, Sandra, for anyone else to connect with me, easy, employmentlawyer.ca, the way to do that. Excuse me. Next question today. And by the way, those joining us, you have some time still. I'm Lior Samfiru, the employment lawyer. You have about 10 more minutes or so. Ask your question, please. I know what always happens. In the last 30 seconds, I get like 5 questions and I can't get to them. So please, there's still some time. Ask your question right now. All right, let's see. Next question from Nita on Facebook. My employer changed my date of hire on my employment record and said they could change this to whatever date they choose. Can they do this? No, and I don't see how they could ever do that. Again, it's not like it's an arbitrary date. There are records of when you started. There's payroll records. There's government records. So no, your employer can't change that, and it's not, well, forget about the fact that it's not up to them. It's actually impossible to change. So maybe there's a bit of a misunderstanding there. If you're not sure, let's have a chat. Contact me through employmentlawyer.ca, and let's look at it together and figure it out, okay? So Maria on Facebook, do you have any information sessions for federally regulated employees? Not sure exactly what you mean by information sessions. Information sessions about what? I'm here every Wednesday, and my colleagues do this more often as well, answering questions. So if you have questions about your status, federally regulated, provincially regulated, ask the question. That's exactly why we're here. Okay, Working Bulldogs on YouTube has the next question. What do you think the chances are the courts will uphold terminations for not complying with employer vaccine mandates? So again, the question is not, are they going to uphold terminations? The question is, are they going to uphold termination without severance? So an employer can let you go, and that's not illegal to be let go, even if you didn't get the vaccine. The question is, are you owed severance? Is the fact that you're not vaccinated, does that deprive you of severance? And no, in my view, the courts will absolutely find that for most people, you are owed severance if you lose your job because of your vaccine status. And frankly, I think employers know that. And that's why we're resolving these cases without even having to go to court, because employers know that they're going to have to pay it. They know what the courts are going to do, and that's why they want to resolve it. So again, it's not about are they going to uphold the termination. The termination is legitimate. It's whether or not they're going to make the employer pay severance. And yeah, in my view, absolutely yes. Again, I'm Lior Samfiru. I'm the employment lawyer. I'm here still for the next little while answering your questions live. You see that little sign there above my head there? It says it's live. It's because I'm live. So ask your question, and let's make sure when I'm done, you have the answers you need. Okay. Fortress Maximus. I remember Fortress Maximus because I love that name on Facebook. It's on YouTube. My employer has requested a list of my medications. Are they allowed to do this? Absolutely not. No. Now, your insurance company, if you're on disability, your disability insurer has a right, but not your employer, okay? It's none of your employer's business what medication you're taking at all. It's not of your employer's business what medical condition you have. The only thing that it's your employer's business is, can you work or can you not work? So if they have, or maybe if you need any accommodation, what kind of accommodation? But if you're off work because of a bad back or because of anxiety, it doesn't matter. It's not of your employer's business. So no, they don't have a right to know your medication. Again, your insurance company, disability insurance, they do have a right to know, but not your employer. Okay. Let's see, continue to answer questions right now. I'm just seeing where I left off. Gail has a very long one. Let's see if I can get through it. Usually, best way is to ask a question a bit shorter so I can get through it, but let's see if I can get through Gail's question. I have been working for a company at home for 8 years. I am paid commission and have always been told that I have to pay my own taxes. With all that I do for the company, which has been everything from sales to interviewing, hiring people, etc., I have been told by many people that I should have been considered an employee. I received the contract to sign and I wanted it checked out, and now I have been told that my services are no longer needed. I feel I deserve severance. I'm 67. Of course you deserve severance. It's very likely, Gail, that you've been misclassified, that you are an employee. Happens all the time. I can't tell you how many times that happens. I literally speak every single day with people that have been misclassified as contractors when the law would consider them to be an employee. So the reason why that's important is an employee gets severance. A contractor likely doesn't. So if you've been there for 8 years, you're 67, based on all those factors, you could be owed as much as a year's pay, 12 months pay. But you can't just get that by telling your employer, hey, give me a check. We need to get involved with that. So easy. Gail, here's what I want you to do. You see that address below me. Contact me and my firm, employmentlawyer.ca. Again, employmentlawyer.ca. We'll have a chat. We'll understand your situation and we'll help you get that severance. Not complicated, not long. We do this every day. That's what you're owed. You've been likely misclassified. In fact, I can't imagine you being more of an employee if you tried. Okay, so Gail, let's have that chat. Not next month, not next week. Contact us now, okay? employmentlawyer.ca. Excuse me. Melinda on YouTube. I work for an advertising agency and I'm classified as a contractor. Again, another one of those, and don't receive any sick days or vacation days. How can I be sure that that is accurate? I don't work for anyone else. Well, generally speaking, if you look like an employee and you act like an employee, guess what? You're an employee. So if you work exclusively for them, they tell you what to do. Essentially, if you have a regular job, you are an employee, and it doesn't matter what the company says you are. It doesn't even matter how you pay your taxes. It doesn't matter at all. So here's one way you can find out, by the way, Melinda and Gail and everyone else, if you're an employee or a contractor. I mentioned already pocketemploymentlawyer.ca. Well, when you go to pocketemploymentlawyer.ca, we have a tool that allows you to figure out if you're an employee or an independent contractor. You answer a few questions there, and it's going to tell you, yes, you're an employee, or no, you're not an employee. Use that. If, in fact, you are an employee, you are owed vacation pay. You are owed everything that an employee is owed. So, and we can help you deal with that if you want. So it's very likely you've been misclassified as well. Again, very, very common thing. And if you go to pocketemploymentlawyer.ca, you can use our tool there to find out how, in fact, what you really are in the eyes of the law. And Melinda says, would it matter if their head office is in New York and I live in Alberta? Absolutely not. The laws of your province where you physically work is what matters. Doesn't matter if the company is in New York or in Europe or in Africa. The laws of that jurisdiction don't matter. It's where you are. So it's irrelevant at all. Let's see. From AJ on YouTube. Code M on the ROE for vaccination non-compliance, can that be appealed? Do you know of any successful appeals? Well, no, you don't appeal it. You simply get the company to issue you a new record of employment, because they shouldn't have put code M. They should have put code K or potentially code A, but that's it. So that's where we get involved. We get the company to issue you a new record of employment. And again, there's also severance that's likely owed to you. So you don't appeal that. You simply get the company to issue you a new record of employment, and you use that to apply for EI. You're not going to be able, unfortunately, to accomplish this on your own. We have to get involved. But as part of a settlement, a resolution with your employer, yes, we'll be able to get a new record of employment that allows you to qualify for EI. Without a new record of employment, you're not going to get EI. Okay, so we need to get that new record of employment. And you can simply contact me, my team, through employmentlawyer.ca. All right. Karen, last question, I think, of the day. What is the purpose of a discovery session? Well, I'm assuming you're talking in the context of litigation. If there's a matter in litigation, if there's legal action, each side has the right to ask questions of the other side. In Canada, we call this discovery. In the US, they call this depositions. That's because, unlike what you see on TV, when you go to court, there's never any surprises. Everyone knows what someone's going to say because we've had these discoveries. So discoveries allows the parties to put their cards on the table so they know what the case is about, what the issues are about, and it's part of every case if the matter doesn't resolve before. My goal always, if there's litigation, is to resolve the case in advance of that. Okay, so we don't have to go to discoveries. But again, if you're going to discoveries, presumably you have a lawyer, so maybe that's a question you want to ask your lawyer. All right, I think I'm caught up on the question, which is great timing because that's the time that we have for today. Always a pleasure to be here, guys. Again, my name is Lior Samfiru. I'm the employment lawyer, one of the founding partners of Samfiru Tumarkin LLP. Great questions here, as always. I've told a bunch of you, you have to contact me, but don't wait. I'll be back next Wednesday right here on social media, but don't wait till then because I can't help you on social media. For you to actually get the help that you need to connect with me and my team. Just go to employmentlawyer.ca. Phone number is there. Email address is there. It's all there. So please, please don't wait. Guys, thank you so much for joining me today. It's always a pleasure and a privilege to be here. We'll talk again soon. And again, employmentlawyer.ca. All the best. Take care.